Hello, my name is Sheriff Asa Buck of Carteret County.
And I am Susan Doyle, District Attorney for Prosecutorial District 13 in Johnston County.
We would like to take this time to discuss changes that were made by the Victims' Rights State Constitutional Amendment that voters approved in 2018, commonly known as Marsy's Law for All.
The constitutional amendment resulted in several changes to existing victims' rights laws in North Carolina. This video will go through those rights and describe what steps need to be taken when working with a victim of crime or their family member.
First of all, everyone who is a victim of a crime has the right to be treated with dignity and respect. New laws afford rights to victims of felony property crimes and crimes against the person, whether the offense is perpetrated by an adult or a juvenile.
The victim, or in certain circumstances, a family member or legal custodian, is entitled to the following rights. The right, upon request, to reasonable, accurate, and timely notice of court proceedings of the accused. The right, upon request, to be present at court proceedings of the accused. The right to be reasonably heard at any court proceeding involving the plea, conviction, adjudication, sentencing, or release of the accused.
The right to receive restitution in a reasonably timely manner when ordered by the court. The right to be given information about the crime or act of delinquency, how the criminal justice system works, the rights of victims, and the availability of services for victims. The right upon request to receive information about the conviction, adjudication, or final disposition and sentence of the accused.
The right, upon request, to receive notification of escape, release, proposed parole or pardon of the accused, or notice of a reprieve or commutation of the accused sentence. The right to present the victim's views and concerns to the governor or agency considering any action that could result in the release of the accused prior to such action becoming effective. And the right to reasonably confer with the district attorney's office. Law enforcement has responsibility to victims under these new laws. As soon as possible, but definitely within 72 hours of identification of a victim, the investigating law enforcement agency shall provide the victim with the following information in writing: the availability of medical services, information on crime victims' compensation, district attorney contact information, investigating law enforcement agency contact information, information about the accused opportunity for pretrial release, information regarding custody, and a list of the victim's rights. The information you must provide victims is contained on the back of AOC CR 180B.
The investigating agency shall also collect the victim's name and telephone number or other contact information. You can use the front side of AOC CR 180B to collect victim contact information. Sometimes the investigating law enforcement agency doesn't make an arrest. In those cases, the arresting agency also has responsibilities. Within 72 hours after an arrest of the adult or juvenile believed to have committed the crime, the arresting agency shall inform the investigating agency of the arrest.
Upon receiving arrest information, the investigating law enforcement agency has 72 additional hours to notify the victim and forward victim contact information to the district attorney's office. If the victim refuses to give contact information, you must inform the district attorney's office. Form AOC CR 180B also provides a place for this notation.
It is the victim's responsibility to notify the investigating law enforcement agency if they want information about the accused during the pretrial process. It is also the victim's responsibility to notify the investigating law enforcement agency of changes in their contact information.
The investigating law enforcement agencies shall promptly share changes and notification preferences with the District Attorney's Office.
Traffic-related crashes and incidents can cause confusion about notification requirements.
A misdemeanor death by motor vehicle requires victim notification. If there is a driving while impaired with physical injury to a third party or felony property crime, victim notification is required.
Conversely, if the incident involves only a DWI, there is no victim notification.
The new law also provides an avenue for victims, or in certain circumstances, others acting on the victim's behalf, to enforce their rights.
If the complainant alleges law enforcement violated the victim's rights, the victim must first file a written complaint with the law enforcement agency. The agency is afforded the opportunity to resolve the complaint in a timely manner.
If resolution does not occur, the victim may file a motion with the court.
Remember, all victims deserve to be treated with dignity and respect.
We must all work together to ensure victims are treated fairly.